Now it's being recorded. Okay. Does that address your concern, Mr.
Yes.
Schwartz? And of course, we can give you a call and talk to you more about it as we update and revise our draft rule to address that.
I appreciate it.
Yeah, make sure we're doing it. Okay.
That's all for me this time. I'm gonna mute myself. Thank you.
Okay. Next question from Ms. Harrison. Bond forms and rules have in the past had the blessing of the AG for collection and the comptroller bond expert. Has this been vetted with them yet, or will it be? I can tell you that we have not approached them yet with it. However, our rules do have to go to the governor's office first. And that is, I think that's the way that we will, if the governor's office wishes to involve the AG or the comptroller in this discussion, I think that's where that will come in. Does anyone who has been with the agency longer than I have a different response? Okay, yes, Matthew says, yes, we will discuss with comptroller and AG. Okay. And we definitely don't want to adopt a rule that doesn't work for them. That would be counterproductive for us as well. So thanks for pointing that out, and we will work that into the process. I think that will probably happen at the same time or contemporaneous with speaking to the governor's office about it. Okay. Mr. Schwartz, your hand is still raised. I assume you don't actually mean for it to be, but okay. Okay, question from Ms. Harrison. Permit life, bond life, officer life. Is it possible a permit holder with several locations will have to post bonds as a result of warnings? I think that's part of the reason that we're putting these rules out there, is to show that we are paying attention to multiple locations and attaching those violations to the person so that they are held accountable with a bond. Does anyone? Yes, if it's a formal written, exactly. If it's a formal written warning. So formal written warning, again, is it counts as a violation for bonds. So if you have one violation at each of several locations and they attach to that person, that officer, then those locations will have to post bond. And Ms. Harrison comments, this could have a huge financial impact on a permit holder that is not prepared for this, especially retailers. Okay, we will take that comment under advisement and take a look at that. And Mr. Cherry says Rule 34.1D explains the written warning. And the way I think about the written warning is just that a warning is a violation without a penalty attached to it, but it does count as a violation. Okay. Are there any more questions or comments regarding section? Okay. Question from Ms. Harrison. Are warnings that are not written captured in the current system, and how will you distinguish? That's a good question. I actually don't know the answer to that. Is there's someone else who can answer how unwritten warnings are, or informal warnings are recorded or not, or tracked. It just got very quiet. Are we still, everyone can still hear me? Okay. Audit or enforcement? Can someone answer the question about whether and how informal warnings are tracked? Or not, if they're not tracked? Okay, let me unmute you, Matthew, and give you a chance to respond to that.
I think the best answer is kind of yes and no. Some of that in the sense of if a permit holder calls in and asks questions and advise that something is a violation, or maybe they reveal that they're currently engaged in that conduct and it's a violation, and they talk to somebody from the agency and then realize, okay, now I am in violation, but they're going to go change kind of what they're doing. I would consider that something that we are informally letting them know that there's a violation, but we're not pursuing a case on that. Not all of that obviously is going to be logged on some document, because we don't record every single phone call that everyone has, but it does get documented in the sense of if something comes up, like in the course of an inspection, an audit is out there and is looking at the premises, and they advise somebody that they may need to fix something. And I'm more or less talking about kind of the innocuous things, like they had a sign that was a couple inches over from where it needed to be, and the agency is not going to pursue any sort of violation and ding them for it. We're not going to end up issuing a formal written warning where they get a notice and a ticket, but those discussions and everything are going to be represented in the report and documents that get drafted, memorializing the inspection and what occurred during that inspection.
Okay. Let's see, Ms. Harrison has asked to ask a question, so I'm going to find her and unmute her. Okay, you are on.
Thank you. As you all know, I'm quite frank, and warnings are often, or have been often, used for tracking purposes to show performance and prove performance, and location inspections to legislators as well as the governor. I think a good example has been COVID and all of the number of warnings that may or may not have been issued, and whether those have been consistently recorded by agents that are recording these, or auditors. And therefore, because I know there's probably been a lack of consistency and warnings have been issued, I just got to be very strong about the fact that I believe warnings should not be counted. If a warning was a warning and it wasn't worth issuing a violation, then why should it go against my bond, which is going to give me financial penalties? I'm really having a hard time wrapping my head around a warning counting as a violation and causing me financial penalty to the state when there is no consistency as to how warnings are recorded. And warnings, as we all know, are recorded to show productivity. So I just have to get that out there on record. I think that this will be very, very harmful to our industry, personally, and for my clients. Thank you.
Thank you. And just as a point of clarification, if the warning is issued is recorded due to the current written warning rule, which is that 34.1 that we discussed earlier. Okay. Are there additional comments or questions? Regarding 33.41, we need to move on. We've only got about 20 minutes left to talk about this. So if you do have additional comments or questions, feel free to, as always, feel free to email them to me, and I will call you back. 33.42 is specific to performance bonds. There's a little bit of repetition here because some things that apply to performance bonds also apply to surety bonds. So we've got some of the sections of current 3324 beneath our applicability section. And then we have, again, some specific provisions for forfeiture of performance bonds, which varies a little bit from surety bonds. So you'll see here, this is, you know, the standard language of our authority to seek forfeiture for violation of any statute or rule. But then here, for violations of cash credit law, the first 6 incidents will not be counted, and the 7th and subsequent will be counted. The difference here is that there's a statutory requirement that violations for safe harbor not count or will count toward conduct surety, but that does not equally apply to performance. Questions and comments about 3342, especially subsection D. Now, and I understand that some of the same comments and questions that you had about the prior forfeiture sections will also equally apply here. Same comments apply. Ms. Harrison notes her same comments apply. Yes, I understand. We'll note that for the record. We'll move on to 33.43, when excise tax bonds are necessary. We've just moved that over wholesale without change. Right now, we don't have any excise tax bonds on file, and frankly, as an agency, we're going to have to consider how we're going to use that in the future. And so we've decided that that's a conversation for another day, and we're just moving this over for now, and sometime in the future we'll talk about how we're going to handle those excise tax bonds. For now, we're just maintaining the status quo. There's a little update here to the numbering. Again, this excise tax bonds 3344, moving basically wholesale from 3322 with a few non-substantive changes, just adding some numbering. That first, there was a giant fat paragraph that really needed to be broken out a bit, so we broke that out a bit, you know, changing some spelling. And then this section has just been broken out and put into its own section. So it's the same language. We just broke it out from here and gave it its own section. And that's just something that me as a rules person, when you're trying to cite something, it's better to have its own section if it's a separate concept. So we've moved it there. The things that are deleted here are things that moved into the general provisions up at the top. So there aren't any substantive changes here. Things have either been moved to general provisions or moved over as they were. Again, we're not really addressing excise tax with this at all. Are there questions or comments about either of the excise tax proposed rules or draft rules? Okay. We'll go ahead and move down to bonds for alternating brewery proprietorships and contract brewing arrangements. Here we have moved current rule 3327 over, given this section a applicability section up at the top. Tell you it's just for these particular types of arrangements. One change we have made here, there's a requirement that the bond be posted by certain permit holders that if they do not own a fee interest in a brewing facility. We've added whether foreign or domestic, whether domestic or foreign, because that question has come up in multiple circumstances in the past. And so we thought it would be best to just go ahead and clarify and rule that we do mean a brewing facility in the United States or elsewhere. A fee interest is a property interest. These items that have been that are struck here again are moved up to the general provisions at the top just to reduce the duplicative language. Here, these are some non-substantive changes that just update. I've got some non-substantive changes that just update the references. And again, on subsection F, which is current 3327J, I've just broken that out in a little bit different way. So it's just renumbered. And then finally, subsection G there at the bottom, the commission may seek forfeiture of a bond under this section for a violation of any one or more terms of the bond. This hasn't been in the rule, but it's just a statement of what our legal authority is. So it's not creation of authority. It's just a statement of the authority we already have, but wanted to go ahead and put that into the rule to make it clear. And of course, concurrent with this, the current bonds rules 33, 21, 22, 24, and 27 would be repealed. Are there questions or comments about this final section of the bonds subchapter, bonds for alternating brewery proprietorships and contract brewing arrangements? Okay, I'm not seeing any raised hands. And nobody in the chat. Okay. Excellent. Ms. Harrison comments, bonds are getting more and more difficult. And we are hoping that by revising these rules and consolidating them, we would make it a little bit simpler and easier to understand, fewer rules. That was our aim. Okay, with that, thank you for keeping us on track here with time. So we have an hour and 15 minutes to address the remaining three. And again, if you think of something on bonds, we can always go back. So feel free to raise your hand or comment. I'm going to pull up my next rule. Draft sanctions for regulatory violations. As I mentioned at the beginning, you have all seen this rule before several times, but I have made some updates to it, which are underlined. Essentially, what we've done with the chart, you all had a lot of questions about what the chart meant because it just wasn't clear. We had created that chart with using what are the codes that are essentially that our computer systems use, and we had tried to translate those codes into violations, and it didn't work very well. And so what we did was go back to that chart And rather than using the codes, we just we decided on which violations were amenable to being in that chart. In other words, they are pretty standard violations that don't require a whole lot of individualized consideration. And we made sure that we had the statute and or rule that creates that violation. We tried to make the descriptions a little bit better so that people can understand what we're saying the violation is about. And then we also eliminated any references to code provisions that allow us to cancel a permit or suspend a permit, because this chart is about penalties. We always have the ability to suspend or cancel under those code sections, but the purpose of this chart is to begin the process of calculating a penalty, and it's not related to suspension or cancellation. So with that said, those are the changes we made to the chart. It cleaned it up quite a bit, and I hope that it made it more understandable for y'all. I'm really interested in your feedback on that. But that said, what we've done up here to make sure it's very clear is that I had to reword A a little bit in order to have B, which is to make sure that it's understood that the penalty chart is non-exclusive. So if something's not in the penalty chart, that doesn't mean that we will not penalize you for it. It just means that, it's one of those either very rare circumstances, rare violations, or it's one that the penalty varies so much that we felt that it wasn't appropriate to put it into one of the three categories that we have. So we don't want to, we're trying not to, hamstring ourselves into saying, we've come up with every possible violation here. Rather, for these violations that are in the chart, this is where we're going to start with your penalty. So those are the changes to both A and B. And then again, as I told you, we removed all of the in-chart references to cancellation or suspension authority because we're trying to limit it to a penalty amount. And so I have added subsection G to remind everyone that, regardless of this penalty chart, we still maintain this authority under various code provisions to suspend or cancel a license or permit. With that said, I will turn it over to y'all if you have any questions about these changes, or if you have any suggestions for the penalty chart that will help us continue to clarify it and make it more user-friendly. Okay, Ms. Harrison asks, am I understanding that if I fail to timely file franchise tax, hotel tax, sales tax, I may get my bond forfeited and be required to post a bond at all my other locations, even if I pay those liabilities with penalty and interest? Is failure to pay ever, or been late? This is a question for audit. So failure to pay state franchise tax or hotel tax or sales tax. Can someone from audit raise your hand and let me know how that's going to be handled? And I know we discussed this. Director Jones, is this something you can answer? I'm going to go ahead and unmute you if you have a response for how the franchise tax, hotel tax, and sales tax will be. And we're not intending to change the way that we enforce any of these violations. We're just intending to capture in the chart the base penalty amounts. Okay, it looks like I'm going to have to take that question down and get back to you with a response. Unless anyone, Director Jones or anyone else has a response. Okay. We have a record of this chat, and I will ensure that you get a response on that. The best I can tell you right now is that we are not intending to change the way it's currently done. Ms. Harrison's next question is, would someone please explain how this will be regulated and how they will enforce provisions of the tax code? With all due respect, you are changing things as you are now enforcing warnings. Matthew, do you want to respond to the enforcing warnings or any other? Let me go ahead and let Ms. Harrison speak. Hold on just a moment. You're on.
Thank you. Again, I don't want to take up a lot of time, but when you change how you're going to forfeit and require the posting of bonds, then there is huge impact. Bonds cost money to retailers regardless of the methodology that they use to post them. So now if you write a warning because the permit holder was late to file his franchise tax, late to file his sales tax, perhaps late to post his sales tax bond, there's 3 warnings. There's a conduct bond that now I'm being hit with, not to mention my performance bond. And performance bonds were created for certain counties, quite honestly, for the barrios, which is putting a financial burden on more minorities than anyone else. And now we're going to count warnings when we're in the middle of a pandemic, and we all know people are going to be filing these reports late. They're lucky if they're able to make the payments. I have serious issues, and I apologize for taking up time, but I really wish that someone would explain to us how this is going to be monitored, how is it going to be communicated to the permit holder so that they understand what their obligations are and understand the impact that a warning and the payment of their sales taxes, how that's going to impact their alcohol beverage permit. Many permit holders don't even connect their franchise tax with their alcohol beverage permit. This has serious impact. Again, I appreciate the time.
Mr. Cherry responds, his understanding is not a change with warnings as that's referenced on the field settlement form that a warning counts as a violation. And we were not intending to change that and discusses it impacting the bond. So we weren't intending to change that. And so we'll look at it more carefully. But I believe the way that the rules currently written and the way we've been operating, we have been allowing warnings to impact the bond. And I'm sure there is some enforcement discretion that is exercised in that regard, especially during the pandemic. But we have heard your comment and we will take it under advisement. You are on, Ms. Harrison.
I appreciate everybody's time and the fact that we're just moving things over and they were as they were before, but nothing is as it was before. Nothing in this industry is the same. So rather than moving things over and keeping them the same as they were before, I would appreciate we recognize that our industry has had huge impact and has changed. Nothing is as it was before. Thank you.
Okay, Mr. Schwartz asks, is it fair to say the penalty imposed for applicant not qualified, second page furthest right column, in the middle violation would only be applied to an existing permittee? In other words, if someone without any TABC permit is denied a permit as they aren't qualified, then they would not be fined. But if the same occurred to someone with an already existing TABC permit, then they could be fined. I am thinking back to the conversation we had about this, and you pointed this out last time. The applicant not qualified, I believe, is intended to apply to subterfuge situations. But let me see if anyone else that was part of that discussion remembers what it was. Let me take a look at that particular violation in the look at the statutes and rules that it just a moment so I can answer your question. I am not seeing that in the revised chart. Are you looking, Mr. Schwartz, are you looking at the one that was posted? To board docs for this meeting? Because I think we may have gotten rid of that language because it was confusing. But it is intended to apply to subterfuge and not to someone who simply has their application denied because they are unqualified. But I'm not seeing it on the chart, so I'm thinking we may have removed that or changed the language. Yeah, exactly. It's not on the chart anymore, so you may be looking at an older one. We removed it because it looked like we were penalizing a denial, which is not what we intended to do. So instead, we were intending to, those are sections that are intended to address subterfuge situations, and so we revised it and took that out. So, and that was something that, first of all, I just want to say thank you for that comment last time. That's one of the reasons that we decided to go through this chart and really refine it, make sure that it made sense to most readers. Okay. Are there additional questions or comments about this revision? We do intend to move forward with it. In the next cycle. However, as the proposed effective date would be in March of 2021. So originally we had thought by the end of the year, but due to everything that's going on and the training that will be involved with this and the associated penalty policy and penalty calculation worksheet, we're pushing that out to March. Any other questions or comments about this one? And then, okay. Ms. Harrison has a question about a new form requesting the release of bonds and asks, would someone please discuss this new form and its impact on future bonds as related to the rules? Strange timing. That is not in the purview of this rule change. So what I will do is I will copy that question and send it to someone who can respond to it in the audit section. But because that's not being changed by these rules, I would rather do that in a separate discussion. But I will copy it and make sure it gets to the right person. And I'm just making notes right now. I apologize for the delay. Okay. Let's see. If there are no additional comments or questions about the draft sanctions for regulatory violations rule and the changes, we will move forward. Hold on just one moment. Okay. We may be able to go back and answer some questions about the bonds in just a couple of moments, but let's go ahead and get started. Okay, we're going to go back and try to answer some of the questions on bonds that we were unable to answer before. Director Jones is back on the call. Okay, and I also missed reading one of Ms. Harrison's comments. Overall comment for bonds, please consult bonding companies on the financial impact they believe this will have on permit holders. Okay, we're going back to Ms. Harrison's question. As I am understanding, if I fail to timely file franchise tax, hotel tax, sales tax, I may get my bond forfeited and be required to post a bond at all my other locations, even if I pay those liabilities with penalty and interest. Is failure to pay ever or been late? Director Jones, do you have any response to that or any clarifying questions to clarify the question? You are unmuted.
Hello, Shana. To answer that question, I mean, we're not changing any of the internal practices as it relates to sales tax, franchise tax, hotels taxes, et cetera. I mean, currently we don't issue warnings to those folks today. However, upon notification, from the state, we do summarily suspend those accounts until they are current with their sales, franchise, and hotel taxes. If they remain in a delinquent status, then a permit stays summarily suspended until it expires, and we don't take any other further action on those particular accounts. However, on the ad valorem taxes, folks that are failed to make payments to the city, local municipalities by statute, if they remain delinquent beyond 21 days, then we're required to cancel or possibly cancel their permit for failure to pay those taxes. So as a result of that, we are issuing warnings to those folks to give them a heads up that, hey, you're a delinquent to your local municipality, you have to make payment or your permit could be canceled. And so as a result of the cancellation on those, that's why we're issuing warnings to those folks in advance. And it is a formal warning. I need to follow up with licensing to see if we're currently using that warning to impact their security bond.
Okay, Ms. Harrison, I'm going to unmute you because I'm not understanding the written comment. So if you could explain it a little bit more You are on.
Thank you. Dexter, failure to pay state franchise tax, $250, $500, or $1,000. You and I both know that I don't remember ever writing a ticket for any of this or ever writing a warning for failure to file franchise tax. My point is, if it's not being used and you've never done it, why did we put it back in the rule?
I mean, all of those administrative violations, a good portion of our violations, enforcement and audit, some of those violations are not listed, in the code, along with a lot of the marketing practices violations, right? And so we haven't changed any practices. Those things have been on the books. They are available to the commission to take action. However, like I said, again, with state taxes that are coming in from the comptroller's office, franchise tax, hotel taxes, I mean, we're not taking any formal action other than to summarily suspend the account. So I'm not sure if I'm following
I
what
can
your
respond to
concern or
that.
question is.
Yeah, I can respond to that too. And that is just that, we've also cited in that particular instance, the cancellation and suspension statute, but we just don't want to preclude any avenue we have. That's not to say we're going to take a different avenue, but we don't want to limit ourselves since we do have the authority to impose a penalty. But we haven't been doing that in the past, and we're not planning to change that. It's just we want to leave it open to exercise whichever authority we want to. So,
well, and I appreciate that. I think that answers the question.
okay.
And the answer of the question is that you're going to keep this open because you may very probably use it. So I appreciate that. Thank you very, very much.
Yes, and that goes for the whole chart, just as a clarifying comment, is that, we were trying to capture, to the extent possible, trying to capture the vast majority of our violations that into this chart, and to make sure that we are leaving all of our avenues for penalties open, even though there are a number of violations and not just those tax ones where typically cancellation or suspension is the route that we go. But we just don't want to shut ourselves off from a different pathway that is available to us in our authority. Was there, I think that was the question that I was unable to answer and had to go back to. Okay. I just want to make sure that if there's any other bonds questions that we were unable to answer, that we got to them. And yes, it is my dog, and I apologize. He's very angry with me for locking him in the bedroom. Okay. Yeah, the chart is notice of what we can do, not necessarily what we will do. That's right. Thank you, Matthew. Okay, does anyone else have comments or questions regarding either the bonds rule or 34.3? Okay. We'll go ahead and move on to item number 3 then. Thanks for staying on track with time, guys. Creation of subchapter G emergency orders to add provisions related to determination and appeal of an emergency order. As you all know, we've been exercising this authority with the recent shutdowns, but we are required to adopt a rule. The rule is it's a new subchapter in chapter 33, and it really is pretty much copying the statute into rule. We haven't done much beyond that. We did decide that neither the executive director nor the person suspended will have the opportunity to appeal. In the administrative appeal. So an appeal, beyond that decision, that suspension decision, there of the SOA administrative law judge, it would have to go into the district court setting. So just going through these quickly. General provisions. This is to implement 11614. Here's the subsection B, the general authority of the executive director or his designee to issue a permit. Issue an emergency order suspending a permit or license. That language is straight from the statute. I've added here all hearings under this chapter, including appeals, may be held by teleconference or video conference. I thought that was something we needed to add due to the way it's currently being used and the strange times we're in. But that is the case regardless of whether it's in rule because it's authorized by the government code. Here's the general authority in 33101. Executive director can do this or can delegate a representative to do it on his or her behalf. The term of the suspension shall not exceed 90 days. That's statutory. And the term is not told during any contested case proceeding. So if you contest your suspension, it still runs during that time that you are in an administrative hearing process. Again, still 33103, still straight from the statute. If an emergency order is issued without a hearing, the executive director designee shall set the time and place for the hearing on the emergency order to be conducted by SOA. Contents of the emergency order, we've I guess explained a little bit further than the statute here. Emergency order must contain identifying information, a brief statement of fact supporting the issuance of the order, determination that the determination is required by statute that the continued operation of the permitted or licensed business would constitute a continuing threat to the public welfare, and a statement of the term of the order, including the date on which it begins and ends. Again, 33105, the legislature allowed us to decide how we wanted to handle appeals beyond the administrative SOA proceeding, and the decision was made that neither party could appeal within the SOA construct. So it's there's not a lot here that's different from the statute. This is how we've been operating the last couple of months as we've had to enforce a few folks that did not want to abide by the governor's orders. And so I will turn the floor over to you all for comments and questions. Are there any comments or questions about the draft rules for emergency orders? Okay, I'm not seeing any raised hands or comments in the group chat, so I will move on to the next item. As always, if you think of something, we can go back. The next item is the consumer delivery safe harbor rule. This is under, oh, okay, we have a raised hand. Mr. Edmondson, go ahead, you're on.
Oh, thank you, Shannon. Can you hear me?
Yes.
Great. I didn't mean to cut you off there. I was just going to provide a comment on this. So thank you. Again, my name is David Edmondson. I'm TechNet's Executive Director for Texas and the Southeast. We really appreciate TABC's willingness to work with the technology industry as rules are being developed for SB 1450. I do want to talk to you about a couple of concerns with 34.6, specifically subsection D lays out what a consumer delivery permit holder must provide proof of in order to establish a rebuttable presumption that it has not directly or indirectly encouraged a delivery driver to violate Chapter 57. Unfortunately, subsections D1 and D3 are both overly burdensome and unreasonable. Section D1 requires the permit holder to provide proof that each of the permit holder's delivery drivers engaged by the permit holder in the previous 2 years, quote, have actually attended a driver training program and maintained alcohol delivery training certification for the entire duration of their engagement by the permit holder as a delivery driver, end quote. This seems to be a very high bar. So our reading is that D1 would require the permit holder to show that potentially thousands of delivery drivers working for a permit holder all took the training program and maintained certification for the entire duration of their engagement with a 2-year look back. In other words, the permit holder would fall short if in the past 2 years, one driver who wasn't involved in the transaction at hand, one driver of potentially thousands across the state, let their certification lapse by a day. And we believe it's overly burdensome and unreasonable to force the permit holder to prove that thousands of drivers who weren't involved in a particular transaction did or did not do something. So we request that this language be changed to instead require that the permit holder have policies in place that require a driver to have a valid certification at the time of delivery. And we're also interested in seeking clarification about what proof would be acceptable to the commission. In other words, what would TABC want to see in order to obtain that rebuttable presumption under D1? And then second, and this will be brief, subsection D3 requires that all delivery drivers have, quote, read and understood, quote, the consumer delivery permit holders policies and procedures stating their commitment to not violate Chapter 57. I'd argue that permit holders cannot prove what a delivery driver does or does not understand. So we request that subsection D3 be removed. Thank you again for hearing our concerns, and I'd be happy to work with agency staff to dive deeper into these issues.
Okay, David, and I will give you a call to talk about these concerns more after I talk with the team about it. I think that when we say have read and understand, generally the way that you would prove that is to have them sign at the bottom something that says, I have read and understand this. So that it's their own, it's on the delivery driver to sign something that says that. And that, it's kind of how we do like our policies in the agency. You have to just go in and sign and say, yes, I did read it. And yes, I do understand it. So we wouldn't actually require you to tell us what's in your delivery driver's head. That would definitely be burdensome. But just that would be part of the language that they would have to sign off on. And you did read subsection D1 correctly. It would require a 2-year look back. Everyone who's been employed would have had to take that training. And I understand your comment that could be thousands of people and is unduly burdensome, and that instead you want to have just proof that you have policies in place. Do any of my colleagues have any response to Mr. Edmondson beyond what I have just said? Okay. Yes. So the reasoning behind D1 is that that mirrors what we do for the seller server training for retail establishments. That they have to, all the seller servers have to take that. Yeah. And so, we're trying to mirror that, but obviously, in most cases, well, probably in all cases, there's going to be fewer of those seller servers than there are of delivery drivers. So I understand your comment and your concern. And yes, as Mr. Graham has noted, the proof would just be essentially having your drivers click a box that says, I read and agree. And, I've read this and I understand it. So that's maybe not as difficult. D3 is maybe not as difficult as you were thinking it could be. Are there anyone else of my colleagues that have would like to respond to Mr. Edmondson's concerns? Okay, but we will go back and look at that and consider whether we can clarify or loosen those restrictions. Mr. Edmondson is probably one of the only folks on this call that represents consumer delivery permit holders. But are any of the, instead of going through this line by line, we'll just ask, do any of the rest of you have comments or concerns regarding Rule 34.6 as drafted? Okay, I am not seeing any raised hands or chat messages. Okay, here's a question from Ms. Harrison. Do consumer delivery permit holders post bonds? That's a good question. I don't know that off the top of my head. Does someone else know? Not that I'm aware of. So Mr. Graham says not that there is no bond requirement in statute. So the answer to your question is no. It might be beyond our authority since it isn't in the statute. Ms. Harrison says, so retailer gets their bond forfeited for warnings and consumer delivery permit has no bond posted. Yes, so that's accurate. A retailer could potentially get their bond forfeited for warnings, and it is also true the consumer delivery permit holder has no bond requirement. Again, we don't have such statutory authority to do that. We're just going with here what the legislature has determined. Are there any additional questions or comments on the consumer delivery safe harbor rule? Ms. Harrison would like to speak. I'm going to unmute her now. You're on.
Thank you. I realize the legislature didn't require posting of bonds for consumer delivery permits. I just think it's interesting that there is a same violation that is a public safety violation, sell to a minor, sell to an intox, serve to a minor, serve to an intox. And yet a retailer is looking at getting their bonds forfeited for warnings under those safe harbor provisions, and consumer delivery permit holders with the exact same violations are not being imposed or having the same types of penalties. I realize that's a statute problem. I would hope that the TABC would address that with legislators, because consumer delivery permits are already getting a sharehold of income right now during a pandemic, and yet they're not even being faced with the same type of penalties as the retailers are. And I just think that's a complete unfairness. So I would hope that the commission would address that. Thank you.
Thank you. Mr. Cherry notes, it's partly because the law currently has liability protections for the retailer and CD permittee for driver's conduct. And yes, the agency, of course, doesn't lobby for legislative changes. We have to remain neutral, but that is the place to take that up, that perceived inequity up, to see if they would like to change that in the upcoming session. Mr. Schwartz has his hand raised. Go ahead.
Yes, thank you. Marcus Schwartz, Bracken Schwartz PLC. This isn't an issue now, but I just want to kind of put this out for the commission's consideration, because there are no consumer permittees now that I believe are retailers, but there in the future, I think there will be. And how does one deal with this rule versus the normal safe harbor rule, and which applies in which scenario, and whether you would use one or both to combat that situation if there's a sale to minor or sale to drunk? So I just put that on your radar.
Yes, we're going to have to discuss that more in depth. We're going to have to come up to figure out where to draw that line, which kinds of transactions might be under one versus the other. So we're cognizant of that, and we will be addressing that in the future. Okay, additional questions or comments? Are there additional questions or comments about anything we have discussed today? We still have some time here. If anyone wants to go back to earlier draft rules. Okay, I'm not seeing any more raised hands or comments. So we will call it a day. Again, especially for those of you, most of you who are here both days, thank you for being here for the marathon. And double, especially thank you to those of you who are parents whose kids went back to school yesterday. I'm glad that I just have a toddler and I don't have to teach algebra or organic chemistry or something like that. So Godspeed to you all and good luck in the coming school year. And thank you all for your time and your attention to these rules. We really do appreciate it. And as always, you can contact me by email at shana.horton@tabc.texas.gov. And that is the best way to ensure that I will get back to you with a response in a timely manner, and that your comments beyond what you've got here will be considered. So we do intend to propose these in September. So we need your comments, anything further as soon as possible so we can make changes as appropriate. All right. Thank you all. Y'all have a wonderful weekend.